So it's great to reconnect with everyone. I see some familiar names from Saturday. The event we had with your group was awesome. I hope whoever participated in person as well as online learned something, made some good connections, and are ready to leverage those connections and that information to be successful this year in real estate investing. So I wanted to go through just some title insurance basics and then talk about different types of entities that you can form to protect your real estate investment and yourself, as well as other creative ways to purchase those investments. And Hugo, I'll just ask you for every page if you could just go up. So I am with All Tech National Title Group. They are a title company that my law firm is affiliated with. We are in 38 states. Our underwriters are Fidelity National Title Insurance, First American, and WFG, which is great. We have the ability to underwrite many different types of residential and commercial transactions. Um, and it's just an exciting time to be part of a group that is very forward thinking, that likes to do transactions with investors and leverages a large amount of their capital towards technology so we can do larger volume based deals. If at any time you have any questions, you can let me know. I will definitely be doing a Q&A at the end of the presentation. So if you do want to hold those questions, will now be recorded. I'll answer all of them for you. So Hugo, if we can move to the second slide, please. So what is title insurance? Title insurance is an intangible construct representing a bundle of rights in a piece of property in which a party may own either a legal interest or equitable interest. So when you own a legal interest, you own the fee title. You are the owner of the actual title insurance. That is different than an equitable interest. When we talk about an equitable interest, that could be an example, that could be a contract interest. Sometimes investors will work with wholesalers to get an off-market deal, and those off-market deals are often found by assignment of contracts. So when an assignor or a wholesaler basically goes into contract with an owner, they have an equitable interest in the property, meaning that they have a contractual interest that they're willing to assign or sell to a third party, which is a buyer or an investor for a profit. So that's the difference between an equitable interest or a legal interest actually owning the property and having that fee title. Can we please move to the third slide? So there's different common methods of holding real property and title, what some of those advantages are and disadvantages. You'll see when you go into title personally, and then we'll talk about corporately what those are. So let's just quickly talk about sole ownership. So the advantages of owning title personally in your name is no other parties need to be consulted to authorize transactions. Disadvantages, should the sole owner die or become incapacitated, there may be legal issues when deciding the transfer of title. So if you don't have a will or an estate in place or a land trust in place, it may be hard to ascertain who that property goes to. If we can move to the next slide, tenants by entirety. Typically we see this if you're purchasing a primary residence. Very quickly, tenants by entirety is the way that title can be held between husband and wife. The owners are legally married and ownership is conveyed to them as one person. Title transfers to the widow individually automatically. If the husband or the wife were to die, it's by operation of law. The living spouse would get the title. Advantages, no legal action needs to be No legal action needs to take place at the death of one spouse. No need for a will or probate action is necessary. And then disadvantages would be conveyance of the property must be done together, and the property cannot be subdivided. This can be an issue with divorce. I just want to bring up another really great feature of tenants by the entirety is that creditors cannot go after the marital estate. So again, as sole owner, what we just saw with sole ownership is we saw one of the benefits of sole ownership um, being that, one of the disadvantages of sole ownership was that you needed some sort of estate plan. Again, I'm thinking of you as investors, and what investors need is that estate plan, which we'll talk about with land trusts, which can be effectuated, or with LLCs and operating agreements. And then also with titles, tenants by entirety, that the big advantage there is the marital asset can evade creditors. The creditors can't attack the property. If you do hold your investment in a land trust, the same can be true of creditors within the land trust estate if the action doesn't have anything to do with fraud. Fraud would be the only exception to that. So going further, you can hold, if you're not going to hold the property in a land trust or an LLC or entity, you can hold it by joint tenancy with another partner. The main advantage of this is that ownership will pass to the surviving tenant. By operation of law, you don't need a will or a probate, and neither party needs to be married or related. Disadvantages: financing or use of property for financial gain must be approved by all parties and cannot be transferred by will to an external party after one passes. Creditors who have legal judgments to collect a debt from one of the owners can petition to divide the property and force a sale. So that's something to consider when wanting to hold property as joint tenants. Another way that you can hold property is tenancy in common. So two or more people hold title to real property jointly and equal or unequal percentages of ownership. All aspects of property are shared by the people named on title. Each owner has the right to occupy and use the entire property. The interest percentage simply determines the financial ownership of the real estate. Advantages would be allows one owner to use wealth created by their portion of the property as collateral for financial transactions, and one owner's creditors can place liens only against the owner's portion of the property. So, your portion of the property would be protected if you can have a judgment. Disadvantages: doesn't allow for automatic survivorship rights. Joint and several liability may apply, and liens on the property must be cleared up in order to transfer the total ownership of the property. So you may be asking, why am I going through all of the different ways that one can hold title to a property without doing it corporately? And so I wanted to discuss what those advantages and disadvantages were before we talk about the differences of corporate ownership. So there's different ways to hold a property when you own it as an investment, and any real estate attorney will tell you that the best way to own property is by an entity, because that entity, whether it is a corporation or a limited liability company, a partnership, or a land trust, will shield you from liability. So if that property has certain issues, maybe if there's a foreclosure or a deed in lieu, that liability will only go as far as that corporate entity that we created. It will not affect you personally unless you've signed some sort of loan agreement, a guarantee, or signed on a note personally. Then the lender would have recourse against you personally. But to hold the title in an entity means if there's a judgment against the property, that judgment is only going to go against your entity's name and your property, and not against your personal name. So that, to me, no matter what entity you choose, is the major benefit. So corporate ownership, technically known And we don't really technically call it by tenancy by the servility. Ownership is in severed or separated as rights exclusive to the individual. That's a very like legalese term. Advantages protect shareholders, person's assets from professional liabilities, which we just discussed. Not many tax advantages when using a corporation. You do not want to form a C Corp because a C Corp you will get double taxation once on the corporate level and then again on your own personal tax level. So if we do form a corporation, and some investors do like to have corporations, we will form an S Corp because then it just filters down to your tax level. Next is trust ownership. Legal entities can own property and can be managed by a trustee on behalf of beneficiaries to the trust. We'll go one step further with this. In Illinois, we have something specific called a land trust. And a land trust helps you do estate planning. You can decide who your successors and heirs are going to be. It shields your identity from creditors and from other people wanting to know who's owned the property. And the trustee, you will pay them an annual fee. It's a minimal fee. It's typically $300 to $350 a year. They can receive mail for you. They can sign contracts for you. They can sign mortgages on your behalf to protect the real estate and to protect your identity. It also protects you from certain creditors. Disadvantages would be that cost of creating the trust. The upfront fee with legal fees is typically around $1,000 to set up that land trust. And then there is a land trust agreement that needs to be executed, which describes the property and who the beneficiaries are. The beneficiaries are the owners and who has the power of direction, who can act on behalf of the trust. But I really think the advantages outweigh the disadvantages for a land trust in Illinois, and it's one of the best entities to use to hold property. There's also partnership ownership. We don't really see a lot of partnerships lately. They're usually structured as limited liability partnerships. One general partner is typically responsible for making all business decisions on behalf of the limited partners. Advantages, it protects shareholder person's assets from liabilities. Again, you kind of have that bifurcated wall in place to protect your personal assets. It's good for out-of-state investors, and there are certain tax advantages. Disadvantages would be decisions are made by one managing member, who would be the general partner. And then one that is obviously missing from here is a limited liability company. So out of all of the entities, the most that our law firm forms for investors are limited liability companies. So what's a limited liability company? It's a company that functions, I would say, like a corporation or a partnership, however, has certain benefits under the law. There's a managing member who takes care of the day-to-day duties of the company and the investment, and then the members all share in the ownership. You're taxed on a K-1, which flows through your personal tax rate, which is also a benefit. And it's structured the same way where your liability is, your personal liability is only to the LLC. Your personal assets are protected. Limited liabilities, you'll see, limited liability companies, you'll see are favored by lenders. They like to see investors using limited liability companies because they're used in all 50 states. As much as I like land trusts, there's only a handful of states that use land trusts and really lenders understand them. So I feel land trusts are better for cash transactions, or you get the approval of the lender that you're going to own it in a land trust before we form it. So the lender will approve that type of entity. So how do you track the title of a property? You can track the title of a property by having a title search done by a title company. Very quickly, the three searches that we search are for liens and judgments against the property. So a land search, tax search to make sure there aren't any back taxes and taxes have been paid current. If there are, that would be part of the title commitment and the search. And then a name search to make sure there's no personal liens or judgments that are against a person's name or entity that would attach on to the title of the property. So typically the searcher or abstractor will go to the county and retrieve this information. Now we can retrieve it online through a system that we pay for, and typically these searches will go as far back as 1984. If there's other documents that title hasn't been pulled, we can go further back and order those searches. Let's see. So what is covered in a title abstract? You'll see deeds, easements, encroachments, any type of will or probate matters, liens, surveys, plats, judgments, back taxes, restrictions, covenants, and tax sales. So as an investor, you want to make sure that you understand all of these exceptions on title, or that your attorney can explain all of these exceptions on title to make sure that the type of property that you're purchasing has clear and marketable title, and that you're able to sell or refinance. A lot of times I work with investors and they'll work with getting deals from REO sources or Altisource or auction.com. And they want to make sure, the most important thing to them is they want to make sure that once they buy this in cash or with a hard money lender, they ultimately will have clear title so they can refinance and get into, a 30-year loan, and that they're not going to have any title issues moving forward. So we are on the different types of deeds. So types of deeds, we're going to go from like the least coverage to the greatest type of coverage. So a quitclaim deed is exactly what it sounds like. It is the grantor is quitclaiming whatever interest they may have, if any, in the property. That means if you get a quitclaim deed from an owner or a supposed owner or grantor, if they do not have an interest in the property, they're just quitclaiming you whatever they have. You're not, with a quitclaim deed, it stops the warrants and title. So when we look at a title search, we're going back in history. We're seeing what and how and who has owned that property going backwards. And this is often used to transfer property among family members, to move properties into living trusts, and to remedy any type of title errors. However, quitclaim deeds, they do not verify a grantor's ownership of the property. And in some cases, such as in clearing title errors, grantors or owners knowingly deed property that is not theirs to sell. So you just have to be careful with quitclaim deeds. You want to verify if you do decide to take on a quitclaim deed. I always tell buyers that they want to make sure that they get a title commitment in conjunction with it to verify that the person that's really quitclaiming you their interest has an interest in the property and is able to do that, especially if it's a property from an heir. Sometimes we see that who's been in title is now deceased. There's been no probate, there's been no will, and what the title company is going to rely on is an affidavit of heirship. We want to make sure that all of the heirs are quitclaiming all of their interests, so you don't have an heir that comes back and says, hey, I had a 10% interest in this property. You really don't own this full property. Quitclaim deeds do not guarantee there are no title defects. I've dealt with this before where clients have not taken on attorney representation. They've dealt with brokers or an owner directly, and they've received a quitclaim deed. Little did they know that there was a tax sale looming on the property, and now even though they did pay, a low price for the quitclaim deed, they've now lost their property to a tax sale because they didn't realize that there were taxes that needed to be redeemed, and now that a tax buyer owns the property. So that's something else that you really want to make sure that you are checking the titles to the property to see what's against the property, because a quitclaim deed is not going to cure any type of title defects such as taxes, liens, or easements. Since there are no legal protection against liens or encumbrances, quitclaim deeds involve a high degree of trust and are preferred by people who know each other well. So the next type of deed is a special warranty deed. We'll see special warranty deeds a lot when doing REO transactions. When a bank takes back a property, they will give an investor or a buyer a special warranty deed. It's a limited type of warranty deed. So what the bank is saying is, we're going to warrant title from the time period that we've owned it. We know nothing about title from the time we took over and basically inherited this property, but we will give you good title from the time that we've owned it to the time that we convey to you, new buyer. It provides all the same protections and guarantees as a general warranty deed, which is the best type of deed one can obtain and the best type of coverage, with one key difference. It only warrants the period during which the seller owned the property. If the buyer faced a title claim from someone who had a lien on the property under an earlier owner, the buyer would have to handle the matter on their own and would have no legal recourse against the seller. However, if the buyer purchased title insurance, the insurance policy would likely handle the cost of defending the title. So again, a really great example of why title insurance is important is when you do get that policy, and if there is some sort of claim like this and you can't go back to the seller because it's a special warranty deed, if you've purchased an owner's policy, your title underwriter has a duty to defend you in that claim and to pay for all of those legal fees. Whether you win on the merits of the claim is specific to what that title defect is. However, that's a big win when the title company is paying for those legal costs.
Lisa, could I interrupt you here?
Sale deeds. These typically accompany homes. A home sold at foreclosure. This type of deed transfers title to the new owner, but it does not warrant against encumbrances. Homeowners who purchase a foreclosed home with a bargain and sale deed may encounter tax liens, problematic easements, or third-party claims to title. To minimize risks that come with a bargain and sale deed, some buyers perform a title search, purchase title insurance, and contact a real estate attorney before purchasing a foreclosed home. We really don't see, I really have never seen a bargain and sale deed here in Illinois. I think that these may be done in other escrow states outside of Illinois. I would say that these are very tantamount to quitclaim deeds. Again, you can get these types of deeds. You just want to make sure that you're doing the proper due diligence with understanding what liens need to be paid and understanding who that owner is, giving you or conveying or quitclaiming the interest to you. Any questions so far before I go on to issues on title? Okay.
I have a quick question, Lisa. This is Veronica. When a property is under a land trust, does the owner still qualify for the tax deductions for the property taxes?
Which specific deductions are you referring to?
Property taxes?
So property tax deductions. So do you mean like the homeowner's deduction and the senior freeze?
The redemptions, yes.
So you can only qualify, yes, you could show proof, but for example, the homeowner's exemption, it would have to be your primary residence. for, like a VA exemption or a senior freeze or senior the senior exemption, you'd have to be 65 and older. So, and it has to be your primary. So really those exemptions, yes, you can still get it with holding your primary residence in a land trust, but you wouldn't be able to get those exemptions on an investment property.
Got it. Thank you.
You're welcome. Any other questions?
Yes, I have a question. What would be the cost to do a quick claim deed?
So the typical cost of doing a quick claim deed with my office is $350. And then there's the cost of recording. So depending on the county that you're with, for Cook County, it's $103 that goes directly to the county to record a deed. That's $98 for recording, and then they charge like a mailing fee. So that would be the cost for a quick claim deed. I also would say that you'd want to have us pull title, which is $140, just to make sure that you understand what's on title, because I get a lot of calls, not about quick claim deeds that our office does, but quick claim deeds that buyers have entered into, and then they don't understand why they're responsible for certain liens or taxes that are associated with the property. So it's fine if you understand what the title is, and if you pull it. Another way to pull it, if you don't want to pay for the search, is through the Cook County Recorder site or the DuPage Recorder site, and you can take a look at title and see what's against the property. But I always recommend that be done, and just to make sure that the owner really is the owner, unless you know and trust that person.
All right, and the second question is, does that have anything to do with TODI or TODI?
I don't know what is TODI.
It's TODI, it's an acronym for something. I thought it was like similar to quick claim deeds, but the person does not have, how would I say, it doesn't show up as an asset on their credit report or something like that.
I think I know it.
So I've never heard of it, but that doesn't
I know
mean
what that
that.
is.
A transfer of death instrument.
Yeah, transfer upon death instrument.
Oh, okay.
On death or debt?
Death, when somebody
Death
died.
like dying.
Yeah, okay, transfer on death instrument. So it transfers property automatically when a property owner dies. It functions in much the same way as a beneficiary designation on a bank account. I have to say that I personally have not done any transfer on death deeds, but I'm looking at the actual deed here, and it's not letting me look at this. Let's see here. So it just has specific language that we could add to, any type of deed, really. Not a quick claim deed, but a general warranty deed. We could add that information onto it.
Okay, thank you.
You're welcome.
My brother and I had a property or our mom had a property in Tennessee, and she quit claimed him onto the deed with right of survivorship, so that it automatically transferred to him upon her death.
I'm sorry, I didn't hear your question.
Oh, sorry, Lisa. Yeah, this is Ray, by the way. Our mother owned her home in Tennessee, and before she died, well, a while before, she made a quick claim the deed to him with right of survivorship. So it just automatically reverted to him upon her death.
Yeah, so that's the same as when you hold title as a joint tenant with the right of survivorship. So that's a way that two individuals, and they don't have to be related, can hold title, and automatically by operation of law, if one person becomes deceased, the other person owns that person's undivided half, so would own 100% interest in the property.
Okay, yeah, because that worked out really good for us. It was super simple. We just went and recorded the new deed.
Yes, so that's joint tenancy with a right of survivorship. The difference between that and tenants in common, it's a question I get a lot, is, you know, what are the differences? So tenants in common can be another way to hold title between unrelated parties, and if one of the parties becomes deceased, then their percentage in the property is transferred by their estate plan. So if they have an estate plan, or if they have a will. If they've died without a will, then it's transferred to their heirs per whatever the state statute is. So in Illinois, it would be, you know, 50% to the living spouse, and then 50% to any children. If no children, then it goes up the chain of heirship. So, you know, typically I see when individuals purchase property, if they're not married, a lot of people like the joint tenancy with the right of survivorship, because that does give them a way to with, you know, if one of the two people were to become deceased.
Okay, and so if you have an LLC and the property's owned by the LLC and we're the owners, that's just automatic, right? If, like, say my brother and I own the LLC, equal membership, then it would basically do the same thing just within the LLC.
So no, so with an LLC, that's different. It needs to be written in the operating agreement. So the joint tenancy with a right of survivorship, that's for individuals who are owning title. An LLC, you would want it to be within your operating agreement to say, you know, what happens to your percentage share if you were to become deceased.
Okay,
Because
great.
the operating agreement in a limited liability company, that's the roadmap. It talks about the rights of the parties and the duties and liabilities of the parties.
Right. I gotta check our operating agreement and just make sure that's in there. All right, thanks, Lisa.
You're welcome.
Hey,
Any
Lisa, a
other
question. So
questions?
can you able to put LLC into the land trust?
You can. So, I have, you know, there are certain investors who want that double protection, and so the beneficiary is the land trust, and then and the beneficiary is the limited liability company, and whoever is the member of the limited liability company would have the power of direction upon the land trust. So the power of direction is really to tell the land trust or the trustee what your choices are, how you want things done, you know, if you were to sell, if you were to purchase, things of that nature. So that's all how a limited liability company has an operating agreement is the roadmap. For a land trust, the roadmap would be the land trust agreement. And then also the really nice feature about the land trust agreement is it has the estate planning in it, where you identify who the property would go to upon the death of the beneficiary.
Okay, makes sense because doing the taxes, unless if I own a property, investment property, and if I do all the expense and taxes end of the year, then how does that work with the land trust if I have that property, if I put that property in the land trust?
I mean, it's going to work the same way. From a tax standpoint, I mean, you get taxed by a K-1, and so there's really no other tax benefits. You know, it's the same with a land trust or a limited liability company.
And what happens if I don't use a limited liability to own the property only on my personal name and then transfer to the land trust?
So you own it in your personal name, and then you just transfer it to a land trust?
Yes.
I mean, you can't take certain deductions. So, I mean, that's really more of like a question for an accountant. But, the good thing about using an entity, whether it's an S corp, a land trust, a limited liability company, is you can deduct your business expenses. You can also, there's also a lot of things you can do under the law with depreciation. So cost segregation, you can use 45L, which are actually credits that the government is giving back for certain real estate that's being rehabbed with energy incentives. So there's a lot of benefits you can receive by holding your property in any type of entity. And I
Understood.
would say it's very important to have an accountant that understands what those benefits are, especially with President Biden approving the energy incentive package. It's really, really helped all types of investors, not even, and more so the small investors, to get those same tax advantages and those tax credits and deductions. Did that answer your question?
Yes, you did. Thank you.
You're welcome. Any other questions?
Lisa, one more question. Does the trust, does it still have the asset protection? If you have a property under a trust, will you still have that asset protection should you get
Yes, so
sued?
the land trust gives you asset protection. It's one of the benefits of the land trust, much like a limited liability company or a corporation. Um, the one thing that I like about the land trust is it protects your identity. So a lot of times, you can look up on the Illinois Secretary of State's website, you can see who the manager is or who the president is of a corporation. So people can look on or creditors can look on the Cook County Recorder's website, kind of do some due diligence, take a look at the Illinois Secretary of State's website to really drill down to find out what assets, someone would own. With a land trust, there's no way of finding out who owns that property. So it's a vehicle that I feel gives you even more protection against creditors even knowing what you own.
Because of the privacy, so sort of like a privacy mechanism.
Correct, because any type of legal notice would go to the land trust, and then the land trust would contact you with what that legal notice would be.
Okay.
If,
And
if I
also,
have a, right.
so the way we're setting things up today, Lisa, just to share with you, and I would like to get your opinion. So
Sure.
our real estate is held under like S corp or LLCs, and then the owner of the LLC or S corp would be the trust, and the main objective is for estate planning and to avoid probate, right? So
Yes.
if when we pass, we want our children not to ever go through the court system to open up the probate and so forth. We just want them to take over everything immediately.
And so a
Having
land trust effectuates that. So it's by operation of law. So the only
right,
thing, if that were to happen, if the beneficiary were to pass, the only thing they would have to show the land trust department is a death certificate just to prove
exactly,
that the beneficiary has actually passed, and a copy of the land trust agreement, which is a private document. And the property would then be conveyed by operation of law to whoever the heirs were who are identified in the land trust agreement.
right. So the reason why we do it that way is because of for funding
Hmm.
reasons. I think you cannot get funding easily should you want to buy a property under a trust. So certain lenders are very iffy about that. They just want you to own it under your entity, like a commercial loan. So that is
Yeah,
why we
so
use the trust in the
sometimes
back end.
lenders, it really just depends on the lender. Sometimes
Yeah.
lenders understand land trusts, and then other lenders, they don't like it or they don't understand it if they're an out-of-state lender. So The way that we get around that is we'll have clients that will close in the LLC or in their name, and then we'll record the, we'll basically convey the property into we'll open the land trust and then convey the property into the land trust after closing.
Okay.
So it would be owned first by the LLC. It would be purchased under the LLC and then inserted into a land trust after.
Yes.
And
Now, it doesn't shield you. I mean that shields you from liability and creditors, but if you default, obviously, on your loan with your lender for your property, so your acquisition and construction loan, that's not going to shield you from that liability. Does that make sense?
Yes.
how easy is to put the property into the trust and take it out, like in case if we like to sell it? So is there like is there a cost obviously to do that?
Yeah. So it's approximately $1,000 to, there's a cost to the land trust. There's a cost to completing to the land trust company. There's a cost for to complete the land trust agreement, to record the deed, to put it in, so deed and trust. The cost of taking it out would just be to have the land trust. So the land trust will actually draft the trustee's deed, and they actually sign the deed as the trustee. Again, shielding the beneficiary's identity from the public. And it would just be, to take it out would just be the cost of recording that deed, which is that $103.
So would that then would the land trust just be dissolved, or like say
Yeah, you would just close it. There's a form that we fill out, and it just asks if you want the land trust open or closed after you deed the property out. Sometimes people own multiple properties in a land trust. Sometimes people only just own one property in a land trust, much like an LLC or a corporation. So you would just fill out that form that the land trust needs in order to create the trustee's deed, and then you would just close it. Again, the annual fee, I believe with Chicago Title Land Trust Company, is $350 to just monitor and keep that land trust open on an annual basis.
So if one of the owners of the LLC passed away, say I died and my brother still has it, then would he want to keep that still in a land trust? The property would that would then he would be the owner because I'm gone from the LLC. Would he just keep it in the land trust, or would
Yes,
he?
he could still keep it in the land trust. I mean,
Would there be any
I've
kind
done
of
it with
extra
people.
benefit from that?
The benefit is then he has estate planning, right? For when he passes away, he still remains, his identity still remains private on who owns the property. Um, so it's still beneficial. Individuals open land trusts all the time, and just own their homes and land trusts.
Okay, I get it now. Thanks.
Yeah. Any other
Hi.
questions?
Yes. Does the operating agreement needs to be recorded when
No.
you have?
The
Okay.
operating agreement is a private agreement between the members and the manager. And so that agreement you want to keep. It's never recorded. However, your lender is going to want to review it, and the title companies is going to want to review it. And the reason why lenders want to review that agreement is they want to make sure that the parties that are signing on behalf of the entity have the authority to do so.
Oh, okay. Thank you.
You're welcome. Any other questions? You know what? If you can just give me a minute, my 6-year-old is playing something really loud, and I just want to make sure that that is not, like, you all can't hear that. So just give me just a second.
Okay, guys, this is a very informative seminar with Lisa. So in a nutshell, it's very critical and very important for pretty much all of you who have or hold real estate to have a land trust, and primarily for estate planning, right? Because you don't want your heirs to go through probate. Okay.
Okay. Any other questions on entities or deed forms?
Yeah, I have a quick question. I know you mentioned Chicago title. From last time I checked, I think their annual fee was like 100 and something. Or is that a different type of trust?
So land trust, the annual fee is either $300 or $350. It's been that way for years. I can re-verify a quote and get it sent, but that is the annual fee
Okay.
for when you have a trust and they're basically, you know, that's just their annual fee for monitoring and managing the land trust.
And then, like you said, any mail, and you could get mail there
Yeah,
pertaining to
so
that.
they can collect, you know, they can be like your legal agent for your address.
Just for that address in particular, or just as
For
a.
10, you know, typically it's 10, the one that I use for clients is 10 South LaSalle
Mhm.
in the Loop. And so they're on the 28th floor.
Okay. Thank you.
And if you want more specific information, we work very closely with a trust officer there. Her name is Rachel, and I'm happy to, if you email me, I'm happy to share her information with you directly and just
Okay, sure.
introduce you.
Okay. What's the email address?
You know, if you email me, because I don't have it right next
Oh,
to
okay,
me,
okay.
I can send it to you.
Okay, thank you very much.
You're welcome.
We'll share Lisa's contact information with all of you.
Any more questions?
Lisa, I have a quick question. This is Brad here.
Hi.
Um, Hi. So, can the does the trust essentially function as like a holding company, or does it supersede a corporate structure? Or I'm just trying to understand the framework for
It
that. Like, for
does. It does
example, if
kind of
I owned a
function
lot of
as a holding company. So, um, you know, they're holding the real estate for the benefit of the beneficiary. I mean, on commercial transactions, commercial lenders tend to understand land trusts more than residential lenders. And so on commercial transactions, you'll actually see certain lenders like brick the trust. They'll like lien the trust. So you need to actually get them to release that brick in order to assign or to sell any interest in the trust. Um, what used to be popular with investors, I'm not really seeing it now, but 10, 15 years ago, you would see assignments of the trust interest, and the only thing that would be recorded with that would be like a facsimile, just letting the public know that there was an assignment made, but you still didn't know who the owner of the trust was. So it does function as you know, a holding company for the real estate.
and you can hold, I mean, obviously LLCs, but you can hold an S corp
Yeah, the S corp can be
as
the
well.
beneficiary.
Okay, thank you.
You're welcome. Any other questions? Okay, if there's no other questions, I'm going to get back to my presentation. So going further on here, hold on one second.
I have it up on the screen, Lisa. So the
Oh,
next
thank
slide
you.
is issues on title.
Yes. So I'm just talking about specific issues on titles, just things that investors should be aware of. Certain easements. So easement rights, you'll see when you review a survey that a neighbor may have an easement, which is a right of way. So it's a grant of a non-possessory property interest that grants the easement holder permission to use another person's land. Easements can affect property owners in a couple different ways. An affirmative easement, like the right to cut through your yard to get to the school behind it, prevents you from blocking the easement of owner's access to your property. A lot of times you'll see these affirmative easements for lake rights or water rights or beach rights. A negative easement prohibits a landowner from doing something with their property. If there's an easement held on your property by an individual or entity, that party has the right to access your property within the guidelines set by the easement. The good thing to know is that easements are of public record. They're a recorded document. I will say that once, I've been practicing since 2008, and once on a closing that I did, it was a short sale for an investor a couple months ago, there was a private easement between the parties, and they did have the document with them, and then we were able to give it to, I was closing at Fidelity, we were able to give it to Fidelity, and Fidelity did add it to the title, but that's a very, very unique situation. Also, easements, different types of easements are with local utility companies. So, one that you'll see a lot in Chicago is like the back 5 feet of the property. You can't put anything on the property because the utility company, the gas company, has an easement there to access power lines or cable lines on your property. Next would be encroachments. Another way to just identify an encroachment is to look at the survey of the property to see if your property is encroaching on someone else's land, or if their property or structure is encroaching on your land. And that can be a fence, that can be a building, that can be concrete, driveway. So one property owner violating their neighbor's rights by building or extending some features and crossing onto the neighbor's property lines. While encroachments may seem harmless, it can lead to liability issues, damage to your property, and problems at the time of sale. So typically, if it's a large encroachment, sometimes you'll see a garage encroaching. I've had that before. If it's encroaching on a public way, so in an alley or onto public property, the title company will not insure over it. If it's a fence, no title company will insure over any type of fence because it's the cost of removal and replacing that fence. However, if it's a small encroachment of a building that's been open and out in the public for a long time, the title company will give you coverage over that. So if you were to have a claim in the future, the title company would handle that because they've given you insurance over that encroachment. Next,
Lisa,
title.
I have a quick question. Is there any way, can someone get an easement against your property without your knowledge?
So yes, if there was a previous property owner and they entered into an easement agreement with the neighbor and it wasn't recorded, that would be an exception to somebody having an easement. But typically it needs to be a signed agreement between.
All right, because my situation is I got a sewer line that runs from my neighbor's house and it goes through my yard out to the street for the sewer line. And he asked me if I would grant him an easement, which basically would say he could dig up my yard anytime he wanted to
Right.
check that. But I said no, I don't want to do that.
Yeah, so in that case, right, if you're not granting the easement to him, then he has a problem.
Right. So, I purchased a home like 20 some years ago, and when I purchased a home, that would have come up on the title search, right?
If there was a public easement recorded, yes, it would have come up on a title search from either the survey or it being recorded with the county. You should take a look at your title policy and your survey.
All right, great, thanks.
You're welcome. Any other questions? Okay, so next title issue is a lien. We all know what liens are. They can be liens by the city for building code violations, for unpaid water, unpaid bills, even a mortgage. So a mortgage is a lien on title, and that lien is released from title once the mortgage is paid in full. So one property owner violating their neighbor's rights by building or extending some feature and crossing onto their neighbor's property lines. When filed against your real property, a lien gives the lien holder the ability to foreclose on your home. This is why, as part of the mortgage process, lenders will have a title search completed. So one caveat here, liens have priority. And so the reason why, if you've always wondered, why do I have to pay as an investor for a lender's policy? We all see that, $550 lender's policy fee. It's for this reason. The lender, before they agree to fund a transaction, they need to verify and make sure that their lien is first in priority. Because if their lien is not first in priority, if they decide that they need to foreclose because the buyer or the borrower is in default, their lien can be knocked out and it can be erased. So it's of paramount importance for a lender to always have a first priority when recording their lien, because then they don't have a way to foreclose on the property. Unless it is, I don't know if we're going to see second mortgages come back, or mezzanine financing, then that's obviously different. It's structured different, and there's more risk for the lender. But on typical transactions, that's why you pay for that loan policy, because the lender needs to verify that they're first in priority. A title search will uncover any liens attached to the property's title. Mortgage lenders won't approve a mortgage if the property has, and my computer screen just went out, has any outstanding liens. Because liens are placed on a property which in a liquid type of asset, lien holders can force the sale of the property to satisfy the debt. So that's all within foreclosure. When a property with multiple liens on it is sold, each lien holder typically has a right to proceeds. Usually liens will be paid according to when each lien holder recorded their lien first. The first person to have recorded their lien will be paid first, and so on. However, other lien types, such as property tax liens, may take priority regardless of when they were recorded. So you'll see this sometimes when the city will sell property back. Some of the liens will be erased, or with tax deeds, you see some of the liens being erased. So it just matters, really. It's based on priority of when that lien was recorded. Any questions? And so next is a judgment. A judgment lien is a court ruling that gives a creditor the right to take possession of a debtor's real or personal property if the debtor fails to fulfill his contractual obligations. This lien may be made against an individual or business and allows the creditor to access assets such as the debtor's personal property, businesses, and real estate to satisfy the judgment. So an example of this would be if you are sued personally, then the court will enter a judgment against you, and then they will do a citation of assets to find out how these judgments can be paid. You'll see, with the city of Chicago, we see judgments being filed against properties with building code violations because the violation was never cured and it was never paid. Sometimes I'll see on some of these properties judgments relating 10, 20 years back with interest and fees, and in order to sell the property, those judgments need to be paid in full, plus any interest and fees that are due and owing. Once they're paid in full, we get a release recorded from the city to make sure that we clean up the title. If you owe money to a creditor and don't pay, the party may sue for the balance. If the court rules against you, the creditor can file a judgment lien against you. A judgment lien is considered a non-consensual lien. That's because it's attached to a piece of property without the owner's consent or agreement. So where this is important is a judgment lien is if you own a property in an entity and you are sued personally and the entity is not sued, you know, you may be able to protect that entity and vice versa. If the entity is sued or there's a foreclosure, they can't go after your personal assets. So it's good to bifurcate and have that separation of liability. Once a judgment lien is filed with the appropriate authority, it becomes attached to any personal or real property. Personal property refers to assets such as cars, appliances, or furniture. Real property, on the other hand, refers to things like homes, building, or land. The property must be registered in your name. So if you have a debt that goes unpaid, the judgment lien cannot be attached to your spouse's property. So that's obviously why if you own a home, you want to own it as tenants by the entirety. If you do not own any property at the time the lien is filed, it can be attached to any future acquisitions, provided the lien doesn't expire. In Illinois, liens expire judgment liens expire every 7 years. If they don't renew those judgment liens, then it expires. So when we do look at name searches and if a lien pops up, if it hasn't been renewed, then we do not add it onto the title because it's expired. So that's something to keep in mind as well. Any questions? So covenant and restrictions. So covenants and restrictions, they run with the land. It tells you it's an agreement between two or more parties regarding certain uses of the property. There are two types of restrictive covenants. There's affirmative and negative. Affirmative covenants obligates a person to act. A negative covenant prohibits a person to act. For example, a negative covenant can forbid a homeowner from building a fence. You know, I've seen a lot of like just silly negative covenants from like the early 1900s where you are prohibited to have certain types of property erected on the land or use the property for certain uses. We really don't see those types of covenants anymore, but I do, as a real estate attorney, I'm always checking those documents and reading them to make sure there are no restrictive covenants that would prevent you from using the property in a way that you would want to use it. An example of this came up maybe a couple months ago where there was a restrictive covenant on a commercial piece of property that you couldn't sell a certain type of food for 20 years. And that covenant had just expired. It was great because there was a restaurant going in that wanted to sell that type of food, but that would have been, you know, not a great situation for the buyer if that covenant and that restriction wasn't read in full and letting them know that actually this is expired, we need to remove it from title. In a covenant that runs with the land, that means that it's always going to be part of title. The subsequent landowner of the property subject to the covenant will continue being burdened or benefited by the covenant. That is in contrast to a personal covenant or a covenant that only binds the original parties of the covenant and will not pass to the subsequent parties. To decide whether a covenant will run with the land, different jurisdictions look for different elements. And then there's 4 standard elements, which I'm not going to bore you with. That's more of a legalese term that the attorneys will look for and look at when reviewing title. So why is clean title so important? Clean title is attractive to potential buyers and investors because that means that the property is free of any title issues and can be properly conveyed. It can also help in preventing any costly legal disputes surrounding the land. One other title issue that's not being mentioned here that I just want to raise is bankruptcy. So if a bankruptcy is filed against the land, The bankruptcy court, the seller's attorney or the seller's bankruptcy attorney needs to motion the bankruptcy court and the trustee for them to approve the contract and to authorize the transaction. You cannot move forward with a property that has a bankruptcy lien on it without that approval from the bankruptcy trustee and court. We need to get an order from them in order to get clean title to move forward. So that's something that I get asked quite a lot. And the question usually with investors is, well, even if you get the order, will I still be able to refinance this property in 6 or 12 months? And absolutely. The order, basically cleans the title, allows the title company to waive that exception from title, and that's the only way you can sell it. You cannot, there's no other way to sell it. It would just revert back. Unfortunately, if there was an error and the order wasn't received by the court. It also, so clean title, it can also help in preventing any costly legal disputes surrounding the land. What happens if title isn't clean? You should talk to your real estate attorney. You should contact me. I've seen a lot since 2008, and I'm always learning and always being challenged. That's why I love being in real estate. It's never boring. So protecting your most valuable assets, protection for as long as you or your heirs own the property, title insurance, there's protection from costs, attorney fees, and expenses of defending against matters insured by the policy. So having clean title, protection against certain covered risks. So under the guidelines of a title policy, you're protected against forgery or fraud, the lien of real estate taxes or assessments due and payable, but unpaid. So if there was like an issue with back taxes or redemption, and let's say the title company didn't collect the right amount, you would be protected against that. Unpaid mortgages and other liens that are not on the policy. And then easements or right-of-ways, limited uses of the property, and then unmarketable title. We did talk about a lender's policy. What is the strongest? So, I'll give you this quiz. What is the strongest and most common type of deed? So what is the best type of coverage you can get? Is it a special warranty deed, a general warranty deed, or a quitclaim deed?
General warranty deed.
Yay, you're listening to me. That's great. So yes, the best type of deed is a general warranty deed. That's what we always want to get, but sometimes we can't get those deeds because it's REO or it's auction property or it's a motivated seller. So we can work with general warranty deeds and quitclaim deeds. We just want to make sure that we're doing the proper due diligence. Which type of tenancy allows for unequal portions of ownership? Is that tenants in common, joint tenants, or sole ownership?
Ray, your mic is on.
Does anyone want to answer this one?
Tenants in common.
Who's answering? This is so great. Yes, you're right.
This is Veronica.
Thanks, Veronica. Yes, so it's tenants in common. Joint tenants are usually 50-50, and so tenants in common are usually between more parties. What is the best way to protect your property against title issues? Is it A, pay all your bills, B, keep a copy of your deed, or C, purchase title insurance?
Title insurance.
Purchase title insurance.
And insurance.
I'm sorry?
Purchase title insurance.
Yes, you are correct. So that is the end of my presentation. I do know that Hugo wanted me to talk a little bit about articles of agreement for deed, which I am seeing more of a demand for. I did work on just closed a commercial property for an investor who purchased on articles of agreement, and it is a great way to structure a deal if the seller is motivated and wants to work with you and kind of sees your vision. You know, in this particular instance, my client negotiated a 24-month term where he took possession of the property and is using the property to educate and train individuals. He's a non-for-profit, and worked out a payment structure with the owner where he put a down payment down with him and then is paying on a 24-month term. At the end of that 24-month term, if he is not in default, then the deed will transfer from the owner to my client who is in possession of the property. And so it is a creative way to effectuate a sale. And we were able to, you know, we had an initial closing to sign documents. And then in that 24-month term, then we have the final closing where there is a transfer of the property and a settlement statement between the parties. So that is another way that, as an investor, a creative way that you can eventually become an owner of a piece of property. And if you're interested in learning more about that, you can contact me, and I'm happy to share my agreements and to review the structure of the transaction with you.
Thank you very much, Lisa. So we're going to send the replay to every single attendee tonight, and then we're going to include Lisa's contact information, her team, her website, all the information. So in case you need more information, please feel free to reach out to our attorneys, Lisa's team. But we want to thank you, Lisa, for your time tonight. I know you're pretty busy, your kids, so I greatly appreciate it.
Yeah, thank you, everyone. And again, just please use me as a resource. I really love what I do. I love working with investors. Thank you, Hugo. It's such a great opportunity to be part of this group, and your success is my success. So I'm really looking to work with all of you.
Awesome.
Everyone have a great night. And any
Thank
more
you, Lisa.
questions?
Thank you, Lisa.
Thank you.
Thanks,
you,
Lisa.
Lisa.
Great info.
Thank you.
Awesome. Have a wonderful evening, Lisa.
Thank you. Bye.
Okay, bye. Take care.